Hello and welcome back to Business Law Lectures here. This is Christiana Pruden, instructor of business law at Fort Hays State University. I want to talk to you today about negligence, strict liability, and products liability. So a mixed bag sort of, but not really. It all falls under the category of when someone, some entity, some producer of goods, someone driving a car or blasting a work site doesn't do exactly what they have intended to do or are supposed to do. So first, let's talk about negligence. This is a big area of law, and we've talked about previously, we talked about intentional torts. Intentional torts are actions that obviously are intended or meant to happen. So assault, battery, these are things that one has to actually put forth the effort, know they're doing. They might not know it's assault or battery, but they know that they're doing that action. When it comes to negligence, it is the lack or the not doing, the lack of doing something that someone is supposed to do that creates a negligence situation. So we have 5 elements that we need to talk about. They are, and I'm going to hold this up. You can pause the video and take notes if you want, or just look at what I like lists like this. Okay, so I'm going to hold this up. Hopefully you can see it. These are our 5 elements. We've got duty of due care, breach of duty of due care, factual cause, proximate cause, and damages. These are the elements when it comes to negligence. And remember, for an elements test, we have to have all 5 in order to establish a claim of negligence. So first, duty of due care. Okay? The defendant, or the person who is being sued or being brought into court, had a legal responsibility to the plaintiff, or a duty. So if we're thinking about maybe a vehicular situation, which is, you know, a lot of us, a lot of people drive cars. We have trucks and airplanes engaged in commerce. So the question you have to ask first with the element of duty of due care is, did the defendant, did the person have a legal responsibility to act in a certain way? If we're talking about driving, the duty of due care of someone driving on the road, let's say me, okay, just a regular driver of a 4-door sedan coming to and from work, I owe a duty of due care to other people on the road to drive carefully, drive responsibly, not be drunk, not text, not be distracted, not be untrained or unlicensed. I have a duty or a legal responsibility to the other people on the road with me, okay? So first element, there has to be established a duty or a legal responsibility from one person to another. If it comes to a situation of, another case where we usually hear this is like a slip and fall or something like that. You might have heard those terms. Walmart, we'll just use that as an example, although it could be any business, has a duty to all of its customers to maintain the walkways in and out of the store, the sidewalk, the entryways, and the entirety of the store in a way that people are not likely to slip and fall on wetness due to cleaning or weather. That is a duty that Walmart owes its customers. And if Walmart does not mop up a mess, if I do not drive carefully, then I will be deemed to have breached my duty, or the defendant failed to meet the legal obligations. So if my legal obligation is to drive safely and I don't meet that obligation, I have breached my duty. Okay, I haven't fulfilled the duty that I owe society, that I owe the other people. Now, when I'm driving, I owe a duty to the drivers around me. It is difficult to say that I owe a duty to every single person driving a car in the entire universe, or even the entire state, right? There has to be some sort of circle, geographically or logically, in which I owe a duty to those inside. So if we're talking about driving Let's say I take I-70 to work every day, which I do. I owe a duty to the people within the circle of influence, or close enough that my breach of a duty could harm them. Okay? And this speaks to our next elements. We have factual cause and proximate cause. Now, we break down the causation into two different pieces because we have to have both cause in fact and foreseeability. So factual cause. The way that we like to say this is, but for the defendant's breach, the plaintiff would not have been harmed, but for cause, okay? So if I had not, we're just going to stick with the driving situation. If I had not texted while I was driving, then the woman whose car I hit would not have had damage to her car and potentially bodily damage, okay? The breach of the duty has to be the cause of the damage, of the incident, of the problem. We also have to have something called foreseeability, which falls under proximate cause. That type of harm was foreseeable. Is it foreseeable to me that if I'm driving on I-70 and texting that I may strike someone else's car with my car and hurt them? Let's say she broke a leg and her car is totaled. Is that foreseeable to me? Could I possibly conceive of that, in a reasonable way? Absolutely. Okay, the type of harm that one would assume would occur in a car crash is damage to the car, damage to the person. And in texting, I know I'm breaching my duty, and if it's foreseeable that I would harm the other person in that type of way, then we meet that element, okay? So in my situation, in my example, my duty of due care is to drive safely. I breached the duty when I started to text and drive. It can wait. That was like a little mini PSA. Not that you guys would ever text and drive. Factual cause occurs because if not for my texting and driving, then let's say Linda, I had some lady named Linda, these are just random, then Linda would not have had damage to herself and damage to her car. It's also foreseeable, or there's proximate cause, because that's exactly the type of damage that one would assume would occur if I breached that particular duty, okay? Finally, on our list, we have to have damages, okay? The person who was affected by my breach of duty has to have been harmed or have some measurable financial loss. It is not enough that we just have the first four elements and that I should have done something, I didn't do it, it was the cause of someone else's misfortune, and I should have known better. I could foresee that. The person on the other end has to actually have something happen. They have to have damages. Okay, so those are the 5 elements we have to have. I'll hold them up one more time. Not that I'm just kind of a visual person sometimes, so let's see, straighten that out. That way you can pause, take a look at that. I've got little brief descriptions with each element. And with an elements test, I just think it's important to write these things down, to think about it, because you have to have all 5 in order to establish a case of negligence, a claim of someone not rising to the level legally that they needed to in order to recover in a car accident or in a slip and fall or something like that. So if you are studying negligence in any way, shape, or form, as we are here, you will likely encounter a case called Paul's Graph. Okay, Paul's Graph versus Long Island Railroad. It is a classic, the quintessential negligence case. In Paul's Graph, and I do have a picture that I've drawn, but let me explain it a little bit first. In Paul's Graph, we have a woman on a train platform, okay? Mrs. Paul's Graph. And I'm just going to hold this up, just a little view, okay? We have the platform. I've named platform 9 3/4 because I'm a Harry Potter nerd. But we have an old-timey train platform. We have a woman standing on it, right here, next to a big brass heavy scale. And then we have a man with a package and a porter. When the porter, or the man working for the train, pushes the man to try to get him onto the train quicker, okay? We're trying to keep these trains running on time. The man drops his package, which was actually full of explosives, which knocks the big scale over onto Mrs. Palsgraf, okay? So we've got sort of a chain of events happening here. The man, just calling him the man, has a package with explosives. The porter, in trying to get him on the train, causes him to drop the package, which explodes, which shakes the train platform, and causes a heavy scale to fall on Mrs. Palsgraf. So the question the court is asking here is that type of harm that befell Mrs. Palsgraf foreseeable by the Long Island Railroad? The court talks about it, goes back and forth a little bit, as they always do, but it comes down to the element of proximate cause. Because here, the duty that the railroad owed Mrs. Palsgraf was to allow her safe rail travel, to not interfere with that, to not harm her in any way, shape, or form. The duty was breached because she was harmed. The scales fell on her. So we have damages. The factual cause, okay, but for the porter's throwing of the man on the train or pushing him, would she have been harmed? No, that was his action that eventually caused her harm. But the foreseeability aspect, was it reasonable that that train employee foresee his action ending in that type of harm? Okay, so if you look at the case, you will be able to see that the court talks about how that type of harm in this case is not foreseeable, because how would the man know that there were explosives in the package? However, if the package had a big explosive symbol, you guys have all seen that, caution, explosive, little exclamation point inside of a triangle. If the porter could have seen that, then it would be more reasonable for him to understand the type of harm that could occur due to his actions. But would there be any way for him to know that there were explosives in the package that could cause the scale to fall over, that could cause Mrs. Palsgraf's injury? No, not in this case. Now, if it were, as I said, if the circumstances were a little different, possibly, but it is a classic case that sets up the idea that although it's not as if we can't have a chain of events that holds up a case of negligence, where we still have foreseeability, it does not extend indefinitely. We cannot have something occur that the original actor could not have foreseen and call that negligence. Okay? So when we're talking about negligence, we also have to talk about the liability of landowners. Okay? People who either own private land, ground, houses, businesses. There are different levels when it comes to liability to people who come onto your property. Okay, if you're a property owner, great. If not, you go on other people's property. The first and lowest level is that for trespassers. So a trespasser is someone who, as you probably know, does not have permission to be on someone else's land but enters anyway. Okay, enters without permission. The landowner does not know, and therefore the landowner owes no duty of care to a trespasser. If a trespasser enters your home or your property and falls and breaks their hips, yeah, that makes sense, that's not something that you are ever going to be liable for. However, the only real limitation is that you cannot set up traps for trespassers, okay? There have been actual real many cases about this. Let's say this in particular. You set up a spring-loaded shotgun in your garage just in case anybody ever decides to open the door when they're not supposed to. That's not okay. You cannot try to anticipate harm for someone who is a trespasser, but that, let's say you have a shotgun in your garage, someone trespasses into your garage and they accidentally shoot themselves, okay? That's not going to be a problem. But if you set it up for them to shoot themselves, that could very well be a problem where you would have liability to that person. The next level up is trespassing children. Now, we owe a duty, let's say we as landowners owe a duty to trespassing children to the extent that we might have what the law calls an attractive nuisance. Okay? Classically, the example is a swimming pool. If we have something on our land that could be deemed to attract children, that is hazardous, then you may owe a duty to protect that child, even if they are a trespassing child. Okay, even if a child, walks into your backyard unannounced, you have no clue, and climbs into your swimming pool. I think we've all probably heard of cases where, and should know that, it is our responsibility to have that fence, to not have the ladder in there, because you can and often are liable if a child trespasses onto your land to enter your pool or to play with wires that are exposed. There have been cases about that. So there is a level of responsibility to trespassers when the trespasser is a child. The next level up is for, we have two different levels. We have someone called a licensee and someone called an invitee. A licensee is someone who has a limited license or the owner's permission to be on that land. So a social guest, someone who has your permission to be at your house, a hunter, okay, who has a license to hunt on certain land, or if you're going to a baseball game, let's say the Kansas City Royals, you are a licensee to be in that seat at that time at that game. Okay? And if we're dealing with licensees, the owner, the landowner or homeowner, only has a duty to warn of latent dangers or hidden dangers. So liability for, happenstance accidents and things like that is not there. But if someone's coming over to your house and for some reason you live in a house where the second step on your staircase kind of falls in, it's your duty as the homeowner to warn licensees or people you invite over that is there. If you don't, and someone falls on a hidden danger, then you might be liable for that injury. The highest level for homeowner, landowner liability, this is a landowner, is for an invitee. An invitee is someone who is on public or business property that's open to the public. So we're talking beaches, parks, we're talking Walmart, we're talking any store that you can conceive of. If someone is there, they're invited there, either because it's a public space or because a business is operating, then the landowner is going to owe a reasonable duty of due care to that person. Okay? It is the highest level that we contemplate. It's a duty of reasonable care, meaning if something were to happen to this person that is, partially or somewhat the fault of the land or the landowner, then there's going to be some liability involved. Okay? If you, for example, slip and fall at Dillon's or Walmart, you guys might not have Dillon's where you are, but I think Walmart's a more general example. There's a duty of reasonable care. Okay? Reasonably care for the floor safety and for the safety of the patrons and things like that. That's the highest level. So trespassing adults, you owe almost no duty of due care. Trespassing children, you cannot attract them onto your land, and if you do, you probably will be liable. Licensees are people who come to your house or people who go to a baseball game. There's a duty there, but it's only to warn of hidden dangers. And then at the top are invitees, people who are invited onto a property to conduct business or be in the public space, and there is a reasonable duty of due care, the highest one that we've discussed. Okay, so negligence, we've got landowner liability, and we got to talk too about negligence per se and res ipsa loquitur. Negligence per se is a situation where a legislature has said, look, we recognize that this activity is very harmful. For example, let's talk about maybe drunk driving. There are usually, almost always probably, statutes in a jurisdiction saying you cannot drink and drive. Now, a negligence per se statute sets up the duty and the breach for a negligence claim. So if, let's say, someone in the state of Kansas or something drinks and drives, there will automatically be an assumption that there was a duty and they breached it. Instead of having to try to prove those facts at trial, the person trying to pursue a negligence per se action only needs to prove causation through factual cause and proximate cause and damages. Okay, so it's it makes it easier for someone to be successful on a negligence case in certain instances where the legislature has said, hey, this is a really bad thing. Res ipsa loquitur is Latin, and it is a situation where we have a burden shifting. So ordinarily, the burden is on the plaintiff in a negligence case. The person bringing the suit has to prove all of the elements in the affirmative, in that we have a duty, we have a breach, their breach was the cause of my harm, I did actually have harm, and it was foreseeable. When we have a res ipsa loquitur case, it shifts the burden to the defendant. So the defendant then has to come in and say, it has to prove, I did not have a duty, I did not breach it, etc., etc., etc. And this is really only in situations where the defendant had exclusive control of the item or the occurrence. The example that we like to use is, and it's not just because we like alcohol, but we like to use the example of walking by a whiskey distillery, okay, or somewhere where they store spirits or wine in barrels. And it's sort of just a modification of the air conditioner example that you might have seen in the book. But you're walking by a whiskey distillery, they keep the spirits in barrels, and often they'll stack them up pretty high. So let's say we've got a 5-story distillery, you're walking by, and a barrel breaks through the window, comes down, hits you on the head. Okay, this would be a classic case where res ipsa loquitur would apply, because the defendant, the distillery, had exclusive control over that object, and you had no way of preventing it. You had nothing you could really do. Okay, you didn't do anything. You had no fault in it whatsoever. You might want to pursue a res ipsa loquitur case. Now, could you pursue just a regular traditional negligence? Yes, but as with when we talk about strict liability and products liability, sometimes it just makes more sense to go with those cases if you feel you have the facts applicable. So, connected to that, we have two different types of negligence that apply in different jurisdictions. Most jurisdictions follow some type of comparative negligence format. Comparative negligence means that if the plaintiff, or the person bringing the suit, is more than 50% responsible for the incident, for their injury, then there will be no recovery. That's compared to contributory negligence, where if the plaintiff is at all responsible, there will be no recovery. So contributory, if the plaintiff, the person bringing the case, is even 1%, if the jury, the fact finder, decides, hey, this is a car accident, and yes, it's the other side's fault, but you could have turned half a second quicker and that would have prevented it, therefore this is 1% your fault. In a contributory negligence jurisdiction, or state, country, the plaintiff cannot recover. In a comparative negligence jurisdiction, the plaintiff can recover. Let's say they decided the plaintiff was 1% liable, as in my example. They would be able to recover 99% of the damages that they received. Okay, so contributory is if the plaintiff is at all at fault, they cannot recover. Now, it doesn't mean that the other side wasn't negligent, but they cannot recover money for their damages. Comparative, see, even these are tricky. In a comparative negligence jurisdiction, as long as and we have something called pure comparative, modified comparative, but most jurisdictions have some type of comparative negligence statute, where if it's pure, then if the plaintiff is let's say the plaintiff themselves is 99% at fault for the accident, that the case that they're bringing. They can still recover 1% of their damages. But in a modified comparative jurisdiction, the plaintiff can only recover if they're less than 50% liable, which kind of makes sense. If the person bringing the case is more at fault than the other person, then they're not going to be able to recover. But if they're 10, 15, 25% at fault, they'll still be able to recover a reduced share of the damages they incurred. Okay, so most jurisdictions do follow some form of comparative. Some still follow the rule of if you did anything wrong at all, if the jury even says 1% of this is your fault, you cannot recover for your car damages, for your bodily injuries, for whatever it is. This leads us to strict liability. So negligence is liability with fault. Okay, someone was at fault, they had a duty, they breached that duty, they didn't do what they were supposed to do. Strict liability is negligence with, it is not negligence, it's liability without fault. Okay, so even though someone may have done everything they were supposed to do, they can still be found at fault for someone else's injuries. Strict liability, or liability without fault, only applies in ultra-hazardous activities, ultra-hazardous situations. This is like chemical dumping, blasting, demolition of buildings with explosives, the keeping of wild animals, okay? Ultra-hazardous activities. And if one is engaging in an ultra-hazardous activity, even if they take all the proper precautions, even if the blast site has helmets, has people get far back enough away, if they're taking all the precautions, but let's say one of the bricks that they're blasting just happens to shoot and hits someone's car and breaks out their window, they are still, the company that's blasting the building, going to be liable for that damage, even though they did everything right. Even though they didn't breach a duty necessarily, in the negligent sense, they, in performing the ultra-hazardous activity, sort of just take on that risk. Okay, but the examples that I give are pretty exhaustive of what the law considers an ultra-hazardous activity. Keeping wild animals, blasting construction sites, chemical storage or dumping. Those are the situations that we're talking about. Not driving a car, not, paragliding, or things that you might think are, and really are in a lot of ways, ultra-hazardous. Just those examples I give usually are the ones where the law is willing to put liability on someone even though they did everything right. Okay, that leads us to product liability, which is a little different. So if someone is selling goods in commerce, okay, engaging in commerce, buying and selling, doing that type of thing, they can either be found negligent due to a few different reasons, or there may be strict liability for defective products. Now, product liability negligence can kind of fall under three categories: negligence in the design, negligence in the manufacturing, or negligence in the warning, or not giving the right types of warnings. Negligence in the design means that when they were conceiving of this object, let's go with the hairdryer, because I feel like that's a good example for the warnings. But when they were conceiving of this particular hairdryer, did someone who was, one of the engineers, someone who drew up the blueprints, make a mistake, and therefore this product has been negligently created? Okay, that's versus manufacturing. If there was an issue in the actual building, putting together, let's say the plastic is too thin on one part of it just due to the manufacturing, then that could be deemed negligent manufacturing, which would fall under product liability. Finally, and the one that I think we hear maybe a lot about, is the warnings. There have to be fair warnings on the product. So if we're talking about a hairdryer, if you've ever seen one, you probably know that they have a little thing on there that says, don't use this in the bathtub or something like that. Okay, and believe it or not, just like with, I don't know if we said this yet, but like with every part of the syllabus that might seem a little weird or a little specific, it's there for a reason. So there's a reason they have to put these warnings on the hair dryers, because they were at one time sued for negligence for not having a warning to tell people not to blow dry their hair in the bathtub. Somebody got harmed, and the harm rose to the level of negligence on their part. Now, there's also strict liability for defective products. So if we have a company who's manufactured a defective product and the product caused harm, then we may have a situation of strict liability, meaning the court and the law doesn't necessarily care if you intended to do this, obviously not, if the company was negligent, but they're willing to hold them strictly liable for the damages that occur in the defective product. Okay, so we've got negligence and we've got strict liability under product liability, and we've also just got that overall. Remember, negligence is liability with fault. Okay, someone's been found to be at fault. Strict liability is negligence without fault. Okay, and I want you to remember too the elements of negligence, what they mean, the levels of care required for people that enter onto landowner or homeowner's land. Those are the big takeaways from this area of the law. When we talk about negligence, I think it's just important to remember what we actually have to have. So we have to have someone not doing what they're supposed to do, which causes someone else harm. It was foreseeable that that type of harm could occur from this type of breach of duty, and the other person got hurt. Okay, sometimes it's hard to think about things in context of plaintiff and defendant, because those people don't actually exist until the case is filed, but really that's what we're dealing with here. And a lot of the dialogue around people being sue happy comes down to the negligence category. Was McDonald's negligent in producing and selling and providing customers coffee that could supply second or third degree burns to someone if they spilled it on themselves? Maybe you guys remember that case. Were Pringles negligent when they created a can that you could get your hands stuck in? These are the kind of cases that we hear about a lot, just in pop culture and things like that, to kind of say, oh, people, just sue, they're so sue happy, they're so litigious, whatever. But really, this is an area of the law for a reason. If you owe a duty to someone in a legal sense, and you don't fulfill your duty, you breach it, then they can come and recover the damage that they've incurred because of that. And that's something we have to have for our society to work. So I always try to get that in there, that yes, to some extent, we are a sue-happy culture here in America, but there are reasons for a lot of these laws. The lawyers aren't just sitting around cooking up new ways to make people miserable, even though it might seem like that even in this class. So with that, I'm going to let you go for now. I appreciate you watching this video. I appreciate your participation, and I look forward to any questions, comments, or talking to you again in the near future. Thanks. Have a great night, day, whatever time it is where you are. Bye.